take on the darkness, stare down deceit. Murder in the headlines, justice in the beat. From cold case whispers to killers in disguise, we rip off the mask, expose all the lies. Facts like bullets reload and deliver. Truth cuts deep like a blade in a river. Corruption shakes when the mic goes live. We dig where others won't survive. Games rolling through the smoke. Truth hits hard, no time for a joke. Deceit, murder, we name every name. No restraint, no shame, just flame. Locked on the case, we investigate.
This is 12-Gauge Investigative. Let's jump in.
12-Gauge Investigative, we make them bleed. No games, no censors, just truth. Justice is loud, and we're the sound. This is 12-Gauge Investigative.
Good evening, everybody. My name is 12-Gauge. Welcome to my channel, 12-Gauge Investigative. I hope everybody's had a great week and that you're ending it on a positive note. You know, somebody just sent me this information and I thought, what the hey? Why not go live on about it and let everybody know what these emails really consist of. So without me doing a bunch of babbling, let's go ahead and get into it, shall we? As you're coming in, don't forget to hit the like, share, and subscribe button. And be sure to, hold on a second, let me make it a little bigger here. That way everybody can read these. And make sure y'all can see that. Let me take that off, because that always messes with people. Let me get the black screen in here. Because you know the dark reader is always better to read this in dark than to read it in that white. So here we go. Let me change this over. I always like this view better for whatever reason. Thank y'all for being here, whoever's in here. Say hello in the chat if you're in here. It says, State of Idaho plaintiff versus Brian C. Koberger. It says, come now, the undersigned special duty prosecuting attorney for Latah County, Idaho, and is as an officer of the court, declared to represent the following in support of the state motion for an examination of the defendant pursuant to Idaho Code 18-207 in the motion for extension of time to complete rebuttal penalty phase expert disclosures. Number one, it says attached hereto as Exhibit S1 is an email chain between myself and the counsel for defendant with dates ranging from April 2nd, 2025 through April 7th, 2025. Attached hereto is the Exhibit S2. It's an email chain between myself and the counsel for declaration of Joshua D. Hurwitz. Defendant with dates ranging from April 10th, 2025 to April 22nd, 2025. Attached hereto as Exhibits S3 is the Phase 2 expert report of Eileen Ryan, DO, DF, APA, disclosed by defendant as part of his penalty phase expert disclosures. Attached hereto the Exhibit S4 is the declaration of Jeffrey David Lewine, PhD, disclosed by defendant as part of his penalty phase of expert disclosures, respectively submitted this 25th day of April 2025. Joshua D. Hurwitz, Special Deputy Prosecuting Attorney. Wow, there's a lot of people in here all of a sudden. I looked over and there's like a whole panel full of people saying hello. Well, hello everybody. Thank y'all so much. Let me just get into this. Hopefully everybody can hear me just fine. Hopefully everybody can see it just fine. Let me turn down some of the lighting because it's kind of bright. So let's get on to it. And here's the certificate of delivery. And here is the first email. It says, from Joshua Hurwitz, April 7, 2025, to Ann Taylor, Becca Barlow, Massoff, CC Bill Thompson, Ashley Jennings, Stacy Osterberg, Doris Lunsford, Jen Jaqueen. Motion for examination pursuant to Idaho Code 18-207. It says, Ann, thank you for your patience as we evaluated your concerns regarding our requested examination under IC 18-207. Our positions are as follows. First, our expert intends to include personality assessments in order to perform an evaluation consistent with forensic standards for psychology. Such tests, such as the Minnesota Multifaceted Personality Inventory, or the MMPI-3 Personality Assessment Inventory, or Milan Clinical Multi-Axis Inventory number 4, MCMI-number 4, are standard tools in this field, given that the defendant has opened the door to his mental condition and had identified specific diagnosis. The state is entitled to have its experts conduct complete evaluation to test those diagnoses. You would have the opportunity to object to the admissibility of the state's expert analysis, but we disagree that our expert's examination is limited by the parameters that the defense expert selected. So basically, all that's saying is that these are standardized tests that the defense had opened up that chapter that Brian had mental health issues on this regard. So basically, he's just saying, well, you have the opportunity to object to the admissibility of this, but if you want us to go this way, we're going to have our experts, do the testing and the assessments on Mr. Koberger. It says, second, also believes it is contrary to standard practice to have third-party counsel or otherwise present at an evaluation. I don't read the Santa Stephen case as authority supporting a request to be present. While the court's order permitted counsel to be present in that case, the specific issue does not appear to have been litigated, and I have not found another Idaho case in which the parties litigated whether counsel has a right to be present. Indeed, Idaho versus Payne suggests counsel needs to not be present. A defendant has the right to the assistance of counsel as opposed to the presence of counsel during a compelled mental examination. If I'm missing something in the case law, please let me know. So basically, he is saying right there that he doesn't see any other case in which counsel needs to be present when these evaluations are being presented or executed. So case law carries a lot in these documents, and for those people that don't really understand it, they're going to run around and try to nitpick or cherry pick these documents to mean what they want them to mean. But as I'm reading them right now, I'm not adding to them. I'm not putting my emotional opinion out on them. I'm just reading them for what they are. And I'm trying to give you the best impression of my understanding about these documents. So let's continue on. It says, nevertheless, we're amendable to a procedure that would allow you to be present in the same facility as your client to observe the examination in real time. Our preference would be to find a facility where you could be in a separate room to observe the examination through a two-way mirror or video feed. If that is not possible, we would agree to you being in a room but seated behind the defendant such that he cannot make eye contact with you. To be clear, we're not concerned that you would intentionally interfere with the examination. Rather, our experts believe that even the presence of a third-party observer introduces a variable that can affect the reliability of the testing and results. And that is so true. It's like anytime that I do entry-level assessments, I usually have the parents there, but I don't have anybody else. I don't have their lawyers there. I don't have, anybody involved with the defendant as I'm doing the assessment. So it makes sense that they wouldn't have the attorney in the room. And if they would have them, like they said, they could be in a two-way mirror looking in and out, just so there would be no eye contact, so the defendant would not be predisposed to answer honestly because their counsel is in the room. So please let us know if you will alter your positions. If not, we would intend to file a motion indicating that the defense does not object to an examination in principle, but that the parties disagree regarding its scope and whether the defendant has a right to have his counsel present in the room. Thank you, Josh. So that is basically all that one's saying is, hey, it's come to our knowledge that the defendant has stated that he has some mental health issues, and that we're requesting, expert to assess him with these assessment tools, and we want you to understand that you're not going to be allotted to be with him while he's being assessed, but you can be in another room, you can be on a video feed, or you can be behind him. We just don't want you to have eye contact where he is distracted or feels like he can't answer the questions honestly. So that's what that email was saying, And Heather says, rarely are there attorneys when I do any assessment. See, so I'm not lying. I'm not lying. I'm glad that you're in here, Heather, to second that motion for me, because that's true. We don't have the attorneys in there. And here's another email. It says, to the same people, it's sent to the same people. This one was sent April 4th, 2025. It says, Anne, we agree that you may provide our additional responses under the existing protective order. We will get back to you as soon as possible regarding the scope of the examination and whether we object to you being present. So basically, they're just talking about whether she's going to be present or not again. And then Ann Taylor either sent, and this was the answer to her email, because that's usually how it happens, is the answer is on top. So this was the email. It says, good afternoon. Thank you for providing information for our consideration. We have had a chance to meet and discuss your requests. We want to agree to the extent possible given to the April 24, 25 deadline for the state's mitigation rebuttal. Regarding the nature and scope of the examination, our position is that testing within the scope of that done by our experts makes sense. We object specifically to personality testing and any test outside of what has been done. Along these lines, you will receive a pleading to clarify testing done by Dr. Orr. We recently learned 2 tests were not named in the list of tests, but we were referred to in the body of her January 23rd, 2025 report. The tests are brief visuospatial memory tests, revised BVMT-R, and Ray complex figure test and recognition trial RCFT. Will you provide us with a list of tests anticipated and leave out the personality testing? So you ask yourself what's some of the reason that the personality test, she was asking for those personality tests to be left out? Because possibly they'd already been done. Because as you know, as I've said on the channel, is whenever you are indicted, you have a various amounts of tests that are ran on you to see if you are mentally capable of understanding the charges against you, understanding the outcome of the potential charges and their consequences if you should be guilty. So there are various tests that are ran to make sure that you're competent to stand trial. So all these tests are ran once you're indicted, and they're ran in that process to see if you're able to understand the charges against you and Also, if you're competent to stand trial. So chances are some of these personality tests were ran during that time. So why run them again, right? Regarding counsel being present, there is a case law precedent for counsel being present, attached here for convenience. I personally have been present in past cases where clients sat for an evaluation with an expert for the state. The purpose of my presence is to ensure the case is not discussed during evaluation and examination and for client comfort. We're not claiming any right that would prevent Mr. Koberger's evaluation, just the basis for counsel to be present. In the past, clients have been more comfortable with my presence. I do not participate or offer information in the effort to move this along. Will you reconsider your position? Well, obviously, she didn't read the email that they gave her because he was proposing that she could be in a two-way mirror on video feed or even behind the client where she wasn't in eye contact. So obviously that wasn't good enough for her. I mean, which in all honesty, I don't see the purpose of her being in there. I really don't, because everything that is said is protected by client attorney privilege. And I'm certain that they would not be asking anything about the case that he would feel like he would need to answer. I mean, all he could say is, I plead the fifth. I mean, he doesn't have to answer that part. You know what I mean? He has rights. We have reviewed the discovery request as it relates to our experts. We disagree that our disclosure was incomplete at the time of the filing. Your request for further information pursuant to ICR 16 is the first request for additional information. Understanding CR 16, 2, we will obtain and provide testing data and results conducted by our experts, as well as notes as requested in our Exhibit S-1. While the rule allows 14 days, we are actively working to provide information as soon as possible, again, because of the short time frame. Our responses will likely come in more than one disclosure to prevent delay. We would like these supplemental discovery responses subject to protective order like we have agreed to with portions of our discovery. May we add responses under our existing protective order? Thanks, Anne. Okay. So these are emails that are just going back and forth with both of them. So these have to do with back and forth. It says, well, I don't know if I have ads on or not. Are they too much? I mean, were you being clear on that? Or I don't know if I have ads on or not. I really don't. If they're too much, I'm sorry about that. I didn't set up any of that. It says, Ann, we appreciate your quick response. We can provide the following in response to your question. So here they're responding. It says, while we reserve the right to disclose additional expert, our expert is so-and-so, PhD of blank. Nature of the examination. Here he's talking about what the examination is going to be. So you can't say one thing and do another. That's not how it works. You know what I mean? That's not how it works. It says nature of the examination. The examination would consist of a comprehensive forensic psychological assessment, which most people get whenever they're charged with a crime, because you want to make sure that psychologically they are capable of sustaining the trial process. They're understanding what's ahead of them, what the charges are, what's facing them in this trial process. So that's what the psychological is, which typically includes a clinical interview, the mental status examination, which, what's his mental status at that point in time, the review of relevant records, and our administration of standardized psychological instrument to assess cognitive functioning, personality structure, and potential psychopathology, meaning that there is nothing there that's going to show up that Brian has these type of things wrong with him, interpreting language or, what his cognitive functioning is and things like that. So That's what these tests are all about, okay? Sorry about the little thing there. Number 3, it says, so-and-so would be available at the end of April to conduct his examination. Number 4, we do object to the presence of counsel during the examination, as counsel's presence could interfere with the validity and reliability of the assessment process. In terms of the written motion, we would stand on State versus Samuel, 452, page 3D, and then the State versus Hall, 419, page 3D, as far as State versus Payne in Idaho, 2008. So these are the one thing that people don't understand as far as the court process that I interpret based on what they say. They don't understand the case law rules decision making. Many people think that when decisions are made, such as when they were talking about the alternative suspects and things like that, when the judge would say there's not enough evidence or case law to present what you're trying to present, then I have to not allow that into court. It wasn't that the judge was just trying to say, well, I don't want that in the court. I'm not going to have that into my court. But sometimes people misconstrue emotional attachment for validity of the court process, and that's not how it works. There has to be some kind of substantiating factors of evidence or case law to provide certain things to be admitted into the process. And if it's not there, it can't be admitted. And it says, Ann Taylor to Joshua Hurwitz, to Bill Thompson and everybody else involved. This is continuing the motion for examination pursuant to Idaho Code 18-207. It says, good evening. We're seeking additional information in aid of making a decision. Please advise of who your experts are when they want to examine Mr. Koberger and the nature of any testing planned. If you have a written motion for us to consider, please send that for our review as well. And last, let us know your position on one of Mr. Koberger's counsel being present for the examination. So, for whatever reason, the understanding behind all this, there's some kind of misconstrued notion that the defense and the prosecution were not on the same page. That they were not on the same page. Well, if they know what discovery is, discovery tells you that whatever the prosecution has, the discovery has. Whether they had it in the allotted time frame at the same time, well, that's to be argued at a later time. But this tells you that these emails were being sent between the teams trying to get an understanding of what was going to go on regarding the experts. And I'm pretty sure this is how the whole thing went on between the emails, that these two teams were going back and forth, letting each other know, hey, this is what we plan on doing. If you want to rebuttal this, I mean, how are you, we're giving you the heads up, because it's not like, okay, we're gonna comprise a game plan, but we can't let you know what it is. That's not how the court process works. So it's not like there's any hidden agenda that the state knew that the defense wasn't ready to counteract had there been a trial. So all these secrecy things that, one side knew something the other didn't know, I doubt it. Because the discovery process, by the motion to suppression, I'm pretty certain, if not, by that time, all the relevant evidence that was going to be looked at for suppression was already in the discovery process over on the defense's side. Because why would you still be waiting on important stuff to want to suppress for your client and not have it? I'm sure she would have thrown a big fit as far as that's concerned if that would have been the case, but she didn't. She only wanted to suppress certain words, certain statements, certain this and that and the other. So that tells you, if that's all she wanted to suppress, Why didn't she want to suppress any evidence that was being looked at? The White Elantra, the pings, the other stuff that was being shown to the defendant. What made them not want to suppress that? How come they were only fixated on the wording? We don't want psychopaths to be used. We don't want sociopaths to be used. We don't want this to be used. We don't want this to be used. Okay, well, they weren't suppressing. Well, we want the knife sheath to be suppressed because we believe that testing on that knife sheath was done incorrectly. They didn't say any of that. And they would have had to let the state know everything that they were planning on suppressing. It wasn't one of those things that, oh, at the last minute we're gonna show up and we're gonna try to get one over on you and try to suppress all this stuff. That's not how it works. Not how it works at all. So let's continue on. It says, counsel, given the defendant's expert disclosures, we intend to file a motion with the court for an order pursuant to Idaho Code 18-207, allowing the state to have its experts examine the defendant regarding his mental condition. Right here, he tells you, he's telling the defense, this is what we intend to file a motion on. And per Idaho Code 18-207. Please let us know if you consent or object to this motion by Friday at 12 o'clock so we can promptly get our motion before the court. And that's, I guarantee you, more often than not, this is how the communication was going between these counsels. There was no secrecy. There was no, we were the ones that were gagged from knowing certain things. They knew it all. See how they're communicating? Does this look like a secrecy thing? Like they were secretly trying to get one over on the defense or the defense trying to get over on the prosecution? No. This is a cordial email asking for her to either accept this or to object to this. But please let them know by Friday at 12 o'clock so we can get their motion before the court. Cut and dry, right? Is there any questions in the chat so far? Let me stop and see if you guys have any questions in the chat as far as what I'm reading, because, I mean, there is 110 pages of this. Not that I'm going to read all 110 tonight, but I'm going to try to go as far as I can. I mean, I already bored some people. They've already left. I hope they come back. But if you're still here, give a thumbs up in the chat. Let me know that you're enjoying what I'm doing. And let me know that you're understanding the process, because I'm telling you, this is how it works. I deal with this paperwork daily now. I didn't before. I do now. It's all in front of me every day. There's no hidden agendas. It's not like people are teaming up one side and we're going to do this and that and the other to get the best outcome against the defense. It's not a football game. The defense knows the play you're running. Whether they object to the way that you're going to present it, that's another thing. And she objected because there were motions to object certain things. And those motions were denied because they either waited too late or they didn't use the adequate evidence or certain added portions of that motion to allow that to be standing in court. Because had they done that, some of those motions might have passed. They just didn't do their job on the defensive part that they needed to do. And I know the defense doesn't have to prove anything, but they were trying to get these alternative perpetrators into the court process. They were trying to get this dropped. They were trying to add this. They were trying to do this and that and the other. And the reason the judge denied those was because of insufficient either explanation or court law or how it formulated into the court other than speculation. Because you can speculate all day long, but when it comes to the court of law, it's based on facts. It's not based on opinions. It's not based on what you think. It's based on case law and evidence. Everything else is just subjective after the fact. So I guess she's writing back here. Yes, she is. She says, "Hi, Josh. We will object to personality testing. We will object to being excluded from the room, and we will object to any extension of time. Thank you for the update." And so that tells you what she objected to, all those three things. And they didn't have to go before the court or the judge to get that done. They're trying to figure out a way to get all this stuff done before court. She objected to those three things. And let's see what Josh answers. He said, "And we wanted to follow up again about the mental condition examination under 18207. I've attached Dr. Gage's CV, which was produced yesterday. We intend to file a motion with the court to seek an order for the 18207 examination and for an extension of time to make our rebuttal penalty phase expert disclosures so that Dr. Gage can complete the examination and prepare his report. In our motion, we will discuss, look, if there was any secrecy going on, this would not be in there." It says he's telling the defense, "In our motion, we will address Dr. Gage believes the personality testing is appropriate in his professional judgment. The scope of the exam would be consistent with what Dr. Christensen contemplated as was discussed previously. Dr. Gage's position is that the counsel should not be present in the room. So we will take that position. As an alternative, if the court does not grant our request, we will request an arraignment in which counsel is in the room but seated behind the defendant out of his line of sight. From our prior communications, I understand that the defendant opposes psychological testing and wants an attorney present in the room. If anything has changed, please let us know." So how can you read this? Because there's going to be creators that attempt to do this. They're going to say, "See, it wasn't fair. They wouldn't let the attorney in the room. What were they trying to hide? What were they trying to do? What were they trying to get over?" They weren't trying to get over anything. It's usually never done. That's what this whole thing is about. There's no case law that addresses that an attorney should be in the room, and that's what they go on. So all these things that are going to come out about what were they trying to hide? What were they trying not? Why did they want Koberger in there by himself? What were they going to do to him? They weren't going to do anything but ask him questions. That's it. No other nefarious act. But once again, this is what they were given. In their motion, they will address these things. Does this look like a bunch of hidden stuff, a bunch of espionage to keep the defense out of the loop or the state? No, it does not. It says, "Will you also please let us know if you object to the extension of time? We propose a deadline of 21 days after the examination is completed. Dr. Gage can conduct the examination as soon as the court resolves our disputes, and he believes it would take 2 days." So I'm reading these backwards, okay, as I've figured this out just now, because he's asking the question, she's answering on top, okay? So I don't want to confuse you. I'm going to keep reading these this way because if I go all the way down to the bottom, it's going to confuse you. But I'm going to ask you guys in the chat, do you want me to go all the way to 110 and work up? That way you know what the first email or what the first transgression happened, or do you want me to keep doing it like this? Let me know. While you do that, I'm going to fix the title because it's a little off for my liking. And I don't know if other channels are doing this already or they've already done it. If they have, I can understand why a lot of people don't want to come in here and watch it again. It's 110 pages. But I just learned about it. So I thought, why the heck not? Why not get up and do some Idaho tonight? Because I haven't done any in a while. So let's continue on. That was from Josh. And this is from Josh to Ann, April 17, 2025. It says, Ann, following up, we have engaged Dr. Jason Gage as a prosecution expert, and he will conduct the 18207 mental health examination of the defendant. Dr. Gage is ready to receive Dr. Orr's testing data and notes. Here's the website for contact information. Once we have had our chance to talk further with Dr. Gage, we'll be back in touch about setting up the examination. Okay, and this says from Josh to Ann. I know there's a lap, but can y'all answer me something? Because I haven't seen it move. I don't know if it's just being slow tonight, but does this still sound like they were hiding something between the state and the defense to you? I've only read, let me see, what is this? This is number 10. So there's 100 more. Does this sound like a conspiracy to keep one side or the other from having a fair trial? Because that's been the question all this time. Does this sound like these attorneys were working together to get everything needed that they needed to do to get to court? Does this sound like that? To me, it does. It sounds like they're being open and transparent, and they're asking the questions that need to be asked of each other in order to get the questions asked that they're having questions on. Maybe I'll turn the camera off. Maybe that's why people aren't coming in here. It says, Ann, I wanted to respond to your email below to clarify that we're in the process of interviewing and retaining a new mental health expert, and we do not know yet what the position will be at your presence in the room. We hope to find a mutually agreeable arrangement, and we'll reach back out to you when we have retained our expert. So it sounds like they're still trying to retain the expert at this point. And to Josh, says, thank you for letting us know. I will make sure Dr. Orr is aware and does not send any testing data. I also want to update you that Mr. Koberger requests I be present for the state's evaluation and understand I may be seated behind him. So the procedure you suggested works for us. So there you have it. It works for the defense at that point. She didn't have any objection to being in the room, and she was going to be seated behind him. Pretty simple pretty cut and dry, right? From Josh to Ann, April 14, 2025. It says, Ann, we wanted to alert you that blank is no longer able to work on the case. So to the extent she hasn't already, Dr. Orr does not need to provide him with her data. We will be back in touch when we have engaged in a new forensic psychologist in order to discuss the 18207 mental evaluation. Thank Josh. Josh to Ann. It says, Ann, we stipulate and do ask you to redact or not refer to blank as he hasn't been publicly disclosed. We also have a couple requests for you to consider. We will ask the court to take down the video live stream during the testimony of the surviving housemate, DM and BF, to protect their privacy. We don't object to keep the audio going if that is technologically possible. For similar privacy reasons, we will ask the court to bring crime scene victim or autopsy photos are shown. Please let us know if you will stipulate to these requests. We plan to raise these issues in our trial brief rather than the formal motion. So see, they were requesting that DM and BF were taken off panel when they testified for their privacy. which is understandable. I mean, that's understandable. They wanted to keep the audio going, which, they would have been able to. Could have blurred out their face, put a black screen over and whatever. And for the privacy reason, they also wanted to take down the live stream when graphic or disturbing crime scene, victim, or autopsy photos were shown. Whether that is something that would have happened or not, we'll never know. But possibly. Hey, Lenora, thank you for being here. Cuff you, Kels, Heather, PKC. So this is from Ann Taylor to Ashley Jennings. It says, "Good afternoon. This is what we intend to file for our first response. We can redact blank's name since he is not publicly disclosed if you prefer. If so, may we have a stipulation? Thanks, Ann." So once again, what you're seeing is dialogue going back and forth from the defense and the state. And as you see, it's not hiding anything. They're not hiding anything at all. It looks like they're actually working together with the judge asked them to do, did he not? The judge asked them to get along, and he asked them to be certain to not have a circus going on. Do y'all remember that? This says, "Good afternoon." So we'll get back to this other one. That was that. So that was the emails. And these are just blank pages. As far as I know. These are probably redactions. Maybe it's not 100 pages of stuff. Maybe it's... Are these truly blank, or is my computer having trouble uploading this? Has anybody seen this? Is this blacked out like this, or... Hold on. Here's the next one. Because there's a lot of... Let me see it. Yeah, they just look like blank pages. Where's the rest of it, bro? Can somebody tell me what page it starts back up on? First 12 pages? Can you tell me what, you said it's not, the rest is blank. I have this doc. I think it's only the first 12 pages. So only the first 12 pages are actually worth discussing. The rest is blank. Well, that's some bullshit. There's a page right there, but it looks like it's blank too. Well, that's some BS right there. That's what you are saying. The first 12 pages, and the first 12 pages are everything that is in there. The rest is redacted. Yeah, I was just wondering, because, as you see, it looked like there was going to be more, but I guess that's all there was. So, tell me what y'all think about that. About what you just heard. Cuffy says, so that makes me wonder, was it all just really just a nice? You can bet your sweet ass it was. It really was. I mean, I don't believe that it was as intense as people believed it was. Like I told people in the very beginning, you were going to be very disappointed because it was going to be, had it been gone to trial, was it going to be a long, drawn out, you know, a long, drawn out case like people thought that it was going to be? Because if you remember, the crime scene was inside the house. Everything else was circumstantial evidence. So, you know, to assume, oh, okay, HIPAA violation pages. All right, I'm going to show something to you guys that I showed on another video before. And I did a lot of stuff at the very beginning that I wish I would have waited until now, because it would have saved me, would have had me a lot more videos to do. But I did so many in the very beginning. It like I said, I wish I would have waited. So let's see. I'm looking for the autopsy report because there's a difference between what people believe an autopsy is. And let me get to this page right here so y'all can see it. So I'm not just talking to myself. I hate when I do that, when I'll be talking and I'll look up and all I have is just me on the screen. It drives me crazy. It really does. So I'm going to talk about what is an autopsy, because once again, we have individuals that understand it and we have individuals that do not. So I'm going to go over what an autopsy is. An autopsy is a medical examination of the body after death to find out why and sometimes how. So as you saw there, it says, and sometimes how. Doesn't mean every single time they're going to know how something happened. They're merely trying to find out why it happened and how the person died. A pathologist examines the person's external body and internal organs and then writes a report to give to the healthcare providers. So many people believe that Kathy Mabbitt was indeed the individual that did the autopsies. That is false. Kathy Mabbitt's job at that point as coroner, as an elected official, was to just determine time of death and as best as her knowledge, whether it was a homicide, whether it was suicide, whether it was some kind of violent overdose or anything like that. The medical examiner was the person who did the autopsies. They gave the more extensive report that you have been seeing people going over as far as the bruising, the skull fracture, this and that and the other. Okay, so so does that make sense to you guys? Hello, January. Nice to see you. Kels, welcome back. And there are different types of autopsies. There's forensic autopsies. The forensic pathologist performs these. Kathy Mabbitt is not that. She is just a coroner. And I'm not trying to minimize her job, but that is her job. And it's an elected position, meaning that she doesn't actually do the autopsies. So for her to also be a registered nurse, she would have seen knife wounds. She would have known what was a sharp-edged weapon and what was not. So it's not without reason she wouldn't have known that. So for her to say that, would have been, pretty common knowledge. But the forensic pathologist performs forensic autopsies when the death is suspicious, sudden, or possibly involves a crime. It happens as part of the legal or criminal investigation. It can also happen when the death is associated with medical procedures or surgery. Law enforcement, coroners, or judges order that type of autopsy. So the judge, I believe her name was what? Megan Marshall, wasn't that her name? She could have ordered the autopsy to be done by a forensic pathologist or even law enforcement or Kathy Mabbitt. The medical autopsies could have been done at a hospital. Pathologist performed a clinical medical autopsy to understand the cause of a natural death due to the illness or medical conditions. A natural death happens due to an internal factor that causes your body to shut down. There's no injury or trauma involved. Examples include cancer, a heart attack, an infectious disease. The deceased person's next of kin, family members, or a healthcare provider typically request this type of autopsy. So there's two different types. I believe that the 4 victims in this crime received the forensic one because they didn't go to a hospital. I don't believe they went to the medical examiner's office, and I never say this name right. Is it Spokane or Spokane? Somebody let me know. How can you write it out? I never know how to say that, Spokane or Spokane, I don't know. One or the other. It went to that medical examiner's office, and that's where they were having their autopsy done. It says ideally autopsies happen as soon as possible. After about 24 hours, organs and body tissues start to deteriorate, which makes it more difficult to perform certain tests. Forensic pathologists can still do autopsies on decomposed or exhumed, removed from the ground bodies. So, who performs an autopsy? Here's the answer. So, next time that you hear that Kathy Mabbitt, thank you. Spokane. I don't know. Let me make it. Kathy Mabbitt was not a pathologist. All she did was, like I said, concluded that they died, how they died, and the best of her ability, the manner of death. Would she have seen, the fact that she said there was more blood than she's ever seen? That's without saying. She wasn't investigating the crime. She was just looking around, looking at the victims' wounds, obviously. And they were cleaned at the medical examiner's office. You know why they were cleaned? Because at that point, they probably had dried blood on them, and they were looking for more wounds. They were looking for any kind of bruising, any kind of suspicious markings on the body. That's why they were cleaned. They were not cleaned because they were trying to clean off evidence to scrub off somebody else's DNA or whatever. That's not how it happened. They blow. Spokane. Okay, Spokane. Thank you. So they were not cleaned to try to scrub off evidence. They were cleaned because they were looking for other injuries, markings, or anything else that was possibly hidden by blood, tissue, or other thing. So it says a pathologist performs autopsy. Pathology is the branch of medicine that involves the examination of body tissues. You may also hear that a medical examiner performs autopsies. A medical examiner is usually a forensic pathologist who works for the government. And at this point, I don't know if the pathologist is elected or if it is just a hired on position. What is done during an autopsy? And I've done this before. I did this very early on, but it's but it's useful knowledge, especially with all the stuff that's coming out. And I'm going to show you the autopsy report here in a minute and explain it to you because I did it on the Ellen Greenberg case. And hers is very, very specific and it's very detailed. So if you want to see one explained a little more thoroughly, go check out any of those Ellen Greenberg videos in my library. So what's done during an autopsy? The process of an autopsy can vary depending on the reason for it. Forensic autopsies are often very thorough, examining every part of the body. They also typically include crime scene investigation and toxicology, a detection of poison, drugs, and chemicals in the body. Medical autopsies may only investigate certain parts of the body. They typically don't do toxicology as part of the autopsy unless it's done. And that's what Kathy Mabbitt said. She said that they weren't going to want a toxicology done because there was no real reference for it. I mean, they were stabbed to death. That's how they died. They didn't need a toxicology because usually a toxicology would have been a suspicious death. It would have been an OD. It would have been something poison. It would have been something like that, where there's no unexplained bruising. There's no explained marks on the body or anything like that, and they just died. Then you would have ordered a toxicology report. But since she knew how they died, there was no need to order a toxicology report. So there's no reason for that. I mean, there was no reason, so that's why it wasn't done. That's why we don't have any idea whether there was processed food in Xana's stomach, because I'm sure they didn't really need all that because they had other ways to formulate the timeline other than the food. In general, the steps in an autopsy may include the pathologist laid the body out carefully on an examination table in a lab. They thoroughly look at the outside of the body. They take notes on anything that looks unusual or may be related to the death. They may take or request photographs or x-rays of the body. And this is also what I talked about in one of my videos early on, is when they were taking the x-rays, it would tell them, it would even show up the metal of the knife if it broke off in any of the victims. And I'm not trying to be morbid, but this happens. If any of that knife, if any shards or any of that broke off in the body, they would have been able to see it in an x-ray. And they could also tell basically what type of weapon that was based on the chemicals in that metallic item. So for individuals to say they weren't certain that it was a K-bar knife, or to say that it wasn't a knife to begin with, or that they were shot, don't you believe in any of these autopsies they would have found bullet fragments, they would have found a bullet entry hole, an exit wound, or at least the bullet fragment still in the body if it was not strong enough to exit the body? Don't you think that during these x-rays they would find anything foreign in that body that was not supposed to be there? I go with yes, but you can make your own decision. The pathologist uses a scalpel to cut the body from the collarbone to the lower abdomen to examine the inside of the body. They may remove all or specific internal tissues and organs. They take small tissue samples from organs to look under a microscope. The pathologist may cut through the scalp and the skull to examine the brain. They may request various tests on the body, fluid, tissue, and organ samples. They also collect and test any unnatural materials in or on the body, like debris or bullets, in forensic autopsies. So I'm not making this stuff up. I'm not making this stuff up. So after a forensic autopsy, the pathologist places the organ back inside the body, except for the brain, and stitches the skin closed again. After medical autopsy, the pathologist doesn't place the organs back in the body. Once they've completed all their examinations and tests, they will provide an autopsy report which will contain all the information they found. The goal of all autopsies is to find or confirm how someone died, but the forensic autopsies have additional goals or objectives, including establishing the identity of the deceased person if it's unknown. Like we heard that Kaylee was unrecognizable. So to get to that point, you would have to, I guess, do certain tests that would reveal the DNA of the person. That way they would be able to establish the identity if they were unable to get to that point at the very beginning. Fingerprints, there it is. DNA testing may help with this. This is the first time I've seen this, I promise you. Assisting in confirming the manner of death, like homicide or accident, based on medical evidence. Estimating the time of death. So, they really don't need, they don't need all this other stuff, but it does tell you the time of death. It tells you the manner of death and how long does an autopsy take. This is often a question that people have. It usually takes a pathologist 2 or 4 hours to examine a body during an autopsy. They may be able to release early preliminary results within 2 or 3 days of the autopsy, but the full results of the medical autopsy typically take 6 weeks to prepare. Forensic autopsies usually take longer to complete. So I see your comment, and I'm going to answer it, okay? And I understand what you're coming from this. I really do. Tell if intoxicated, unable to defend themselves, a 4X, murder. You can say murder on this channel, okay? I need to investigate everything. This case, in my opinion, is a lack of investigation. I agree with you on certain points, but on certain points, we agree to disagree. I believe that they did investigate a lot more than we've been shown up to this point. We don't have the autopsy report that would be able to tell you all the stuff that you just said, and you're right on that. They should have released that at least. And I'm going to show you, and one of the reasons I believe, and I could be wrong, okay? I could be wrong. Yes, that's what I was just going to say. If they did do the toxology, I don't think it was relevant to the crime. And that's what I was going to say is that the toxology, like I said, had it been an OD, had it been some kind of poisoning, or, they ate some food and then they just started convulsing and they died. There was no visible wounds or anything like that. Then you would have done a toxicology to see what they ingested, what was in their blood, what was in this and that and the other. I'm sure that when we think of toxology, we think of blood samples and all this other stuff. I'm pretty certain they probably did blood samples. I'm pretty sure they did DNA testing. They did all those things. So they would have been able to tell if there was foreign substances in the body. I'm sure they didn't, if they did get into the stomach area, they would have been able to see the processed food or half processed food to determine. But these individuals do this for a living on a daily basis. So chances are they can tell you the deterioration of the body based on how long that body's been there and everything associated with that process. So many times they don't run these tests because they know based on skin tone, skin discoloration, all these other things. And that might look suspicious to a lot of us. You know what I mean? For a lot of us, it might look suspicious. It really would. But if you're in that room and you're seeing all this stuff done, and this isn't your first autopsy, you understand exactly what the pathologist is doing. You know what I mean? So I don't believe that they found any drugs in the system as well either. I believe a long time ago I heard the same thing. You said a long time ago I heard there was zero drugs. They also said the level of intoxication would make them unable to do some fighting back. Now I'm going to turn my camera on for a second just for example purposes. I've also done this example with many times when I've discussed the knife wounds. So whenever there's videos on this in my library, if you want to go check it out, if you want to go dig them up. Whenever somebody is sliced, let's say that you're trying to stop a knife or a yielding suspect, and somebody cut you right here deeply and cut these tendons, or stabbed you right here in the arm, or even cut this tendon, or hit you in the shoulder. What it does, it snaps like a rubber band, so your arm instantly falls down. There is no defending yourself at that point. If you are cut at any portion of this area, the elbow, the shoulder, right here, around the clavicle area, all this snaps like a rubber band. All the tissues, all the muscles, the ligaments, everything had been detached. So your arm no longer has that tautness to be able to hold itself up to even fight back. Even right here, you get sliced right there, or you get cut right there. It's slicing through muscle, it's slicing through tendons, it's slicing through all these things. And believe me, I'm not making this up. If you ever have seen this happen, a dislocation, and the bone cut through the muscle or through the tendons or the nerves, you can have damage where you can't even lift your arm. So to say that they had defensive wounds would have been possibly at the very beginning, unless they didn't have those marks or wounds that didn't enable them to be trying to fight back, not being able to move this part, but being able to move this part because this hasn't been cut yet. If I stab you here and I slice you here, this is going to drop. And you're still going to have your top part, but you're not going to have the ability to hold me off like this. I hope that makes sense. If it doesn't, please go watch the knife wound video in my library. You will see the examples that are given in that one. It's very descriptive and very graphic. So I hope you take the time to go watch that. Let's move on. And here are some of the risks and benefits of having an autopsy done. It says autopsies are important for determining the truth about someone's death. Autopsy findings can provide closure to the families. Forensic autopsies are especially helpful when investigators are suspicious of a crime. They can also help improve health care and protect public health. Potential benefits of autopsies include preventing more deaths. In the past, forensic pathologists have identified public health emergencies like the anthrax terrorist attack. Forensic autopsies have led to the discovery of other public health hazards like defective cribs or car seats that contributed to infant death. Improving medical care information from clinical autopsy can improve healthcare providers' understanding of diseases and how they affect our bodies. It can improve future medical care and treatment for others with similar cause of death. Discovering genetic conditions. In some cases, autopsies reveal that a deceased person died from an undiagnosed genetic condition. This can help biological family members learn more about their risk of having that condition. Providing legal evidence. Forensic autopsies often help with the prosecution of criminal cases like homicides, but there are other ways they can provide legal evidence which may have grounds for a lawsuit. There are minimal risks for autopsies, but possible risks include emotional distress. Families and friends may feel upset about the process, especially if they have cultural or religious beliefs about autopsies. Some may feel uncomfortable with the thought of their loved ones getting examined. The damage to the body. There could be minor damage to the body after an autopsy. This could have an impact on funeral arrangements. Delay in the funeral or the burial. An autopsy could delay services for the deceased person, which can prolong grieving and add additional distress to loved ones. So now we're going to talk about the autopsy report. Does all this make sense? Yes, he did know where to strike. You're right. You're right. I'm not debating you, January. I agree with you wholeheartedly on some of the things you're saying. What's an autopsy report? I'm going to show this to you here in a minute. A forensic autopsy report includes details about everything they found during the examination and testing. It typically states the cause of death and the manner of the death. The forensic pathologist lists the manner of death as one of the 5 categories. So these are one of the 5 categories that they identify these deaths as being: accidental, natural causes, homicide, suicide, or undetermined. As we know, these 4 were homicide. They were not suicides, they were not accidents, and they were not natural causes. While pathologists have extensive knowledge and training, it's important to remember that they're human just like the rest of us. They may make mistakes or be unable to determine what happened. In these cases, family members or legal authorities may request a second autopsy of the body by a different pathologist. And I thought I remember hearing that Ethan's parents requested a second autopsy on him. I can't remember if that was true or not. Can somebody in the chat help me out with that, if that was a true statement or not? I remember hearing that. So this is a note from this website. It says autopsies are a critical part of the medical field and judicial system. It can help determine why and how someone died or advance medical knowledge, but just because it serves an important role in our society, it doesn't mean it's not unsettling to think about. If your loved one needs an autopsy, know that a pathologist will handle their body with care and respect. They'll use their expertise to provide the medical answers they can. So that was very, very beneficial, I believe. I'm thankful for the Cleveland Clinic to provide that. Let me show you right now what an autopsy report looks like. Like I said, this is what I deal with right here. Hopefully you are still here. I believe that Ethan's family requested a second autopsy, but I'm not for sure. Let's see. Let's look at this one. This one seems to be more. I know y'all can't see that one, so I'm going to go over here and show y'all exactly what possibly their autopsies look like. It's very cut and dry. They basically go front and back and everything in between. This says entrance, this says exit, which is with an X, and then the triangle was recovery. So this tells you what Laquan McDonald, 17-year-old male, black male, had all these injuries to his body. So think about that a minute. If you're looking at one of the 4's autopsy reports, and many people, they want to see the photos. I don't know why they would want to see the photos, but they want to see the photos. I don't know if these are knife wounds. It doesn't say. It looks more like bullet wounds. But a knife wound would be kind of the same way. It would be an entrance wound, an exit wound, recovery. And it also would show bruising. I wish they had freaking, what's her name's autopsy report. Ellen Greenberg. Let me see if they have hers. Because hers was a stabbing. And it would show you. Hers was really detailed. I'm not losing internet. I'm just pulling this up. I know it's taking forever. So knife wounds are the same way as bullet wounds, but the fact of the matter is like that with the knife. And once again, I've done a whole 3-part series on that case, but that was the knife that supposedly killed her. This in no means is as long as a K-bar knife. This knife right here. But these were some of the wounds that were inflicted upon Ellen. That's not what an autopsy report would look like of hers. I know I saw it. I think it's in this. Let me see if it's in this case file, and if it is, I'll show this. But Ellen had a lot of knife wounds, and it shows in her report the severity of those knife wounds. It showed exactly where they were, just like that drawing where it was showing. Let me show you right here. Kind of like this right here. Like this shows you the diagram of where the knife wounds were done. Can y'all hear my buddy out there barking? This case is so sad. If you don't know about this case, I suggest that you integrate yourself in the Ellen Greenberg case because it is extremely sad. Not because of anything else other than she needs justice. She needs to be having her killer brought to justice. Okay, where is it? I don't know exactly where that picture is on this page, but if you haven't, it's called Missing Persons and True Crime. This is on Facebook. So basically, this is showing you the description. Let me see what y'all are saying in the chat. You say, I think the 2 autopsy rumors started because Mabbitt said the autopsy were completed 11/16. Okay, that makes sense. Thank you for that. We'll come back. Lenora will be here. Yeah, that is the person. Yeah, it's beyond a suicide. She was murdered. I mean, because like I said, the videos in my library, go check them out. They have Ellen's face. They all have this face on as the thumbnail. So go check them out. And they're in the live tabs, I believe, or in the videos. But as you can see here, it shows how they have shown where these knife wounds were. And chances are they did the same thing with the Idaho 4. I'm not for certain that they did. You know, I'm not for certain, but it would make sense if they did an outline of where these wounds occurred. Let's see. I know I've seen a autopsy reports and incident reports are totally different. Um, Incident reports usually have to do with what happens during the investigation, where you logged it, the chain of custody is usually who had authority to be around this stuff that you're collecting. Jesus, like always, when I'm trying to show you something, um, we're gonna see it. Damn it. Okay, yeah, I think these are different types, but generally when they're being done, they're pretty freaking thorough. What I can tell you is they would be able to tell the difference between a bullet wound and a knife wound. Let me get to that page. I wish this was like some of the college classes that I took. You could literally go from one page to the other without having to unshare. So this basically is a colored portion. So as we know, some of the victims had frontal damage in the skull area, so it would definitely be showing in the skull area. The forehead, they have, I believe one of them had like eye damage. And it goes on and on and on with this diagram, and they write all of it in. And obviously it is used in trial to show the severity of the wounds. So whenever you're talking about these wounds, you want to ask yourself, which I've heard through the grapevines with other people that obviously have time to look at this case throughout the day and stuff. I've been told that they were able to see on some of the victims where the knife cut so deep that it left the impression of the little handle part that keeps you from cutting yourself, that left that in the skin area. So that would have had to be a pretty deep stab in order for that to happen. And do understand there is a difference between stabbing and slicing. Another thing many people do not understand. And I didn't understand it until I did the damn video. Now I get the concept. Most murders, I wish I had a knife, but I'm going to show you. Most murders, when somebody is stabbing at somebody, we think that most of the time they use the ice pick stab. And in that video that I did, it said that probably 5% of people that are stabbed with the ice pick method. That most of the stabs are done straight on. And usually this arm is left open so that you can pull the person towards you while you're stabbing them, while you can hold them while you're stabbing them. So let's say I'm right-handed, so I'm going to punch you, and you're already kind of wounded and woozy or whatever. Then I can switch arms and punch you with my right hand. I mean, it's very possible for all that to happen. I mean, to have this hand free and to pull you close and to be stabbing you like that, it's not without reason. Many people think that all these individuals were stabbed with the ice pick because that is the Hollywood dramatized stabbing motion that most of the Hollywood horror killers they do that. They stab with the downward motion. I believe that if somebody's coming at you, it doesn't make sense to be stabbing them like this, especially if somebody's coming at you. Like if Kaylee was coming at him, if Xana was coming at him trying to get away, why would you be trying to stab her like that as she's moving around? It makes sense that if someone is moving from you, you're aiming. Damn, I almost broke my damn monitor. You're aiming at them as they're walking away. I mean, it's not very hard to understand, you know. No, not like the horror movies at all. Most of the time, it doesn't even happen with the overhead. Now, if Maddie, I mean, there's a lot of people, including myself, very early on, believed that Maddie was laying on her stomach. Okay, but at the same time, if the knife sheath was found under her right thigh, how could she be on her stomach? Unless her thigh was closer to the edge of the bed. I don't know what I just did. I just loaded something that is loading slowly on the screen. Sorry about that. I stabbed the screen and something came up. And now I'm frozen. Can y'all still hear me? I swear I'm always sabotaging my damn lives. What is this shit? My screen totally went away. Okay, y'all can still hear me? Y'all can still see me? Okay. The screen went away. Something was loading and all of a sudden, bam, it was gone. Okay, I'm back. I'm glad that I'm back. So I don't really understand how she would have been. I have always pictured her being on her stomach and he stabbing her from straddling her, stabbing her, and then waking Kaylee up. And that's when that happened. The knife sheath went under her leg, and then he started with Kaylee, and then Xana came up. He ran out, and that's how he left the knife sheath. Not perfectly sure that that's how it's happened, but I don't know. If Maddie was on her stomach, then chances are she didn't have enough time. I mean, think about it. If you're really asleep, I believe Maddie was asleep. I believe Kaylee was partially asleep or not. She may have not been all the way like in REM sleep, but I believe that she was asleep enough to not have heard him come right in. But I could be wrong. Okay, thank you, Sharon. Thank you for that. Steve G had a second autopsy done on Kaylee. Thank you. I couldn't remember who had the second autopsy. I could not remember for the life of me. But and then all that starts with Kaylee, the smashing of the teeth, the cranial damage, the skull fractures, all that. And according to her dad, that would have killed her even if the stab wounds wouldn't have. So one thing else I heard is that Xana had skull injuries as well that we haven't been told about. So that would mean that she herself was possibly plummeted with. See, I believe that my good friend Jeff H. believed that it was used as a hammer. Let me point it this way so I don't stab myself. Let's say this is the K-bar. This is the handle area, right? And it has those little things that keep you from cutting yourself. They would be on this side. So if he has this in his fist like this, and a little part of the K-bar is coming out this way, and the blade is coming this way. So if he's using this as kind of like a handful of quarters or a little pipe in your hand or like brass knuckles, then he's going to do a lot of damage with that thing in his hand. And it also gives him the ability to slash with it and do the overhead stab, like y'all say, and continue to punch without having to shift it from the blade this way to not being able to really punch, because you have the blade closest to you, you're not really going to cut yourself. So if he had a knife like this, with the blade heading this way, it would make sense that he used it to punch. I don't know what y'all think about that, but I've always thought that. And Jeff had always thought that, the end of the K-bar knife was used as a hammer to knock out the victims, which could possibly have been correct as well. We don't know, but it all seemed feasible. It seemed feasible. Doesn't mean that it happened that way, but it makes a lot more sense now that we know the wounds specifically and how the victims were found. It does make sense. So what do you think about what I presented tonight? Did you guys learn anything? Did you learn anything from the emails? Did you learn anything from the autopsies, the autopsy reports? Let me see if I can find an incident report or a chain of custody. Because a lot of these things, people believe that automatically everybody knows what they are, but most people don't have a clue what they are. Oh, I know I didn't. When I first started school, I didn't have an idea what these things were. But I'd heard about them. I didn't know what they were, though. Hey, Allie, how you doing? I hope y'all did enjoy it, because I do put a lot into my presentations, because I believe that you should be given a thorough explanation of what is, especially if you're talking about this case, because it's universal. This right here is the evidence bag. Usually when you fill out a chain of custody report, which looks like this, basically it means who's touched it, who you get it from, by whom, what date, what time, and how many people had the ability to be looking at this evidence. So this is just the form that's going to go along with this. And this has the same type of chain of custody on the outside. All the evidence that is created is documented, placed in this manila folder. Sometimes they're evidence bags, as we've heard. Some of the victims' hands were bagged for later fingernail scrapings and, any DNA or anything like that. It's very interesting as far as this is concerned. So it's all different types, and there's even boxes with evidence. And as you can see, this gentleman is writing out the chain of custody form on this evidence thing. Whoever gets it to look at it, whoever gets it to, if you take it to court or if it's being submitted for testing or anything like that, it's always bagged and tagged, as we say. So very thorough. As far as conspiracy is concerned, regarding this case, I believe there were mistakes that were made in all areas. There's not one 100% error-proof case investigated. There isn't. Because we're having humans doing these jobs, the odds of humans not making mistakes are far to none. You know, gator bait. What? I don't see anybody named Gator Bait. Where are they at? I guess they're way up there. Gator Bait. Well, hey, Gator Bait. That's an interesting name. Like I'm saying, there was, I'm sure, errors done. But as far as corruption and intentional planting of evidence and hiding stuff and all this other stuff, could it happen? Anything's possible. Did it happen? We'll never know. You know? So, I mean, to assume automatically that that's what happened is irresponsible on so many parts. Because for every mistake that people make at their jobs, aren't you trying to keep your job at the end of the day, especially this hard time that we have it today in 2025? And I want you to think about that a little bit, because when we start assuming that these people were doing this maliciously or intentionally, we're saying that they were risking years on the force, years behind the bench, years behind the tables representing people, that they were willing to put their careers and their names dragged through the mud and all that incorporated. I don't believe that anybody would want to do that intentionally. Do people make mistakes? Of course they do. Not one of us is without fault. But I don't believe that they got the wrong person. I don't believe that there was alternative perpetrators. I believe that they were possibly looking at other people. And then once these things started to add up more regarding this one person, it's easy to say that, all the other people we're looking at, there's still a lot of discrepancies. Let's kind of focus on this guy because he's checking more of the boxes of what we're looking for. And then when they find the STR profile on that knife sheath, and then all of a sudden it really takes off. So all of the circumstantial evidence, obviously it scared him enough that he opted for the plea deal. And in doing so, he guaranteed himself a life sentence. I mean, it's interesting to believe that, there could have been so many other avenues. Of course, it's interesting to believe that, But you have to remember, these are real people's careers and lives that we're talking about. I've been looking at probable cause affidavits and court paperwork and police reports and all this other stuff for about 3 weeks now, because I've started a new position. And I can tell you that the PCA that we got on this case was huge, very detailed. Compared to the PCA that I read, which are possibly at most 1 to 1.5 pages long. It is a representation of what you saw during the whole time that you arrived on the scene. As the arriving officers, this is what they saw, this is what they heard, this is what they observed. So it's really interesting to me when something like these emails come out, because I was kind of curious to see what exactly was going to be in those. I was very intrigued. I thought there was going to be 110 pages, and there wasn't 110 pages. Um, yeah, it was a very extensive PCA. The ones I see are like a page, probably a couple paragraphs is that, 3, 4 paragraphs is that. This happened at this time, this date. This is what I saw when I arrived on the scene. This is what the witnesses said because that's what the interviews are for. And this is, what happened once we took the person into custody. This is what they said. This is what the witnesses observed. This is what was seen. And this is why we have probable cause to hold this person. Cut and dry. So, all those other things that we've heard throughout the years, it'll be 3 years in a couple weeks. Can't believe I've been talking about this thing for 3 years almost. That's amazing to me. I was so disappointed when I was reading the emails and then got to all the redaction. I did that too. I was thinking my internet was messing up. I was like, are you kidding me? Is it not loading these pages fast enough? What the heck is going on? I'm very thankful that you guys have been in here tonight. The new people that have came in here, feel more than welcome to continue to come into the chat. I'm hoping to make this chat bigger so that we can have different cases that we can all discuss. Not dividing ourselves from we're right, you're wrong, we're right. But just to listen to the cases as they're presented. Nothing more, nothing less, as I did tonight. There was no emotional attachment. There was no, this is what I believe and this is what I think and this is my opinion. No. True crime really does not have any avenues for those kind of thoughts. At least on my channel. I can't police the rest of YouTube. And I'm only concerned about this channel and that's it, So I hope y'all enjoyed it and I hope y'all keep coming back. Make sure that you tell people that this channel's around because still there's a lot that don't know that I'm even here. Please be sure to hit the notification button so that you do get notified. I didn't get a notification for this and I hit the notification button. That way I can see when it's being put out there and when it's not. That's eerie. That's eerie. She said, I'll never forget this case as I have a constant reminder living in BK area in PA. That's eerie, right? So be sure you do that. And as I always say, stay safe out there and watch your six. Maestro, cue that music.